Okay, Bismillahirrahmanirrahim. Question number 2. Discuss case involving halal certification in Malaysia. The name of the case is Oshigu Public Company Ltd versus Limaway Marketing Corporation 2015 to CLJ 1121. The plaintiff, a public company incorporated in Thailand, was in the business of manufacturing and producing non-alcoholic beverage, aerated water, fruit juice, ready-to-drink green tea and carbonated drink under its trademark Oishi. On 24 October 2011, the plaintiff applied to the Register of Trademark for the registration of the plaintiff Oishi trademark in Class 32, but the application was rejected due to the defendant's trademark in the register. The plaintiff therefore sought to expunge the defendant's registered trademark pursuant to Section 45 Clause 1A and 46 Clause 1 read with section. The issues for the court determination were 1. Whether the plaintiff was an aggrieved party within the meaning of Section 45 and 46 Clause 1 of the Act. Number 2. Whether the defendant's trademark should be expunged for non-use. And 3. Whether the defendant's trademark were entries made in the register without sufficient cause and were therefore wrongfully remaining in the register. Next, the court held, the burden therefore shifted to the defendants to prove that there had been use of the defendant's trademark in the country. However, the defendant had failed to prove that there had been use of its trademark for a continuous period of not less than 3 years up to 1 month before the filing of the application. Alternatively, there had been no use of the defendant's trademark in the country to 1 month before the filing of the application under Section 46 Clause 1A of the Act. Further, the defendant could not rely on Section 46 Clause 4 of the Act as the reason given by defendants for non-use, namely, the halal certification was not formed an abnormal external event but a commercial choice, as the defendant wanted to expand into the halal market. As the word has a well-known dictionary meaning, it was not invented word and thus did not fulfill the criteria for registration under Section 10 Clause 1C of the Act. Hence, the defendant's trademark were registered without sufficient cause and were registration wrongfully remaining on the registered and in the circumstances, the defendant could not rely on Section 37 of the Act. Finally, legislation referred. It is Trademark Act 1976, Section 3 Clause 2, Section 10 Clause 1, C, Section D, Section 14 Clause A, Section 14 Clause 1A, Section 37, Section 45 Clause 1A, Section 46 Clause 1A, B, and 4.